Yes, yes. Thank you.
But
Thank you.
your lordship directed the matter to appear has to be mentioned.
What original
Before
site?
vacation. Yes, yes. And my lord, we also served notice
Okay,
to
let it appear day after tomorrow.
day after tomorrow, kindly. We have already given notice, so we should give again another.
Intimate them.
I'm grateful.
Your Lordship may be allowed to mention an appellate side matter
Yes.
for correction, Your Lordship, in the order.
Yes, give it.
Grateful.
Yes, call the list.
For judgment at number 1.
আজকের ইয়েটা কোথায় লিস্টটা? তো আগের দিনে 24 তারিখে লিস্ট দেখছি।
খুঁজে নেওয়া এখন খুব সহজ। ফ্রিতে রেজিস্টার করুন বেঙ্গলি শাখা।
এটা চিঠি দিতে হবে, চিঠি দিতে হবে।
হ্যাঁ, পিটিশনার
না মেনশন এক্সপ্রেস এটা দিতে হবে না, এইটা দেখো
মানে এটা স্লিপ দিতে হবে, তো আমি দিয়ে দিচ্ছি।
কোন জায়গাটা?
Yes, I am
Respondent number 7.
reading the operative portion. Thus, the judgment and decree passed in CS 72 of 2006 and CS 42 of 2006 on 6/10/2023 and modified on 13/12/2023 and 15/12/2023 will exclude the GST at the rate of 18% and interest, which is rupees 85,18,065. The interest on the basis of increase is rightly calculated by the decree holder. However, before passing any stringent order with regard to execution of decree upon judgment dated Coal India Limited, which is a government undertaking and state within meaning of Article 12 of the Constitution, they should be given a reasonable opportunity to comply the decree. Hence, the judgment dated is directed to pay rupees 5 crore, part of the decretal sum, on or before 17/11/2025. Let this matter appear on 18/11/2025 for compliance report and further orders. না, ওটা ইয়েতেই রাখা হবে, ফর অর্ডার্সই রাখা হবে, কমপ্লায়েন্স রিপোর্ট এন্ড অর্ডার্স।
At number 5.
My lord, this is an application in the nature of a pro interesse suo. My lord, in a suit for partition, there are several properties which are involved. My lord, the receiver was appointed.
Now, what is the application here?
My lord,
Item 5.
this is IAGA number 109 of 2014.
So this application is to be heard out.
Is to be heard out.
Yes.
Affidavits are complete.
Yes.
My lord, there is a pro interesse suo application where my property,
You are for the
I'm for the applicant,
applicant
which is not
intervener.
an applicant intervenor who is not a party to the suit. I do not intend to be either. My lord, one of my properties have been shown to be a property of the my lord, family, in respect whereof the disputes are pending in a
Let
partition.
it appear under the heading adjourn motion.
Yes, my
Let
lord.
it appear. Serve notice upon. You are for the applicant.
I am
Yes,
for
who
the
is for the
applicant.
plaintiff?
No, I am for the applicant. I am with Mr. My lord. I'm for the joint.
Acha, record an order. Learned advocate for the applicant, learned advocate for the joint receiver are present. Let this matter appear on. Huh?
সব দিয়ে দিন। চয়ন গুপ্তা।
Okay. Let this matter appear on 12/11/2025.
অনেক মামলা আছে।
Grateful, my lord, only
The learned advocates appearing for the parties be intimated.
yes, we shall intimate. We have already served them. What we could not serve was some of the cost papers pertaining to the application to the joint receivers. We are serving it here and now in court.
Okay, necessary service with regard to the relevant documents be made in the meantime. With regard to the relevant documents be made in the meantime.
But we have already served the joint receivers. Now, there are other applications in connection with the
I've
suit.
kept
We
it
are
on-
not concerned with that.
No, most probably they will be appearing on those matters will be appearing on 12/11.
But then your lordship would kindly keep it separately because we have nothing to do with any of the, any
Anyway,
other
let us see
application
let us see on
of any of
12/11.
the parties to the suit.
Let us see on 12/11.
Very
Number 6.
My lord. My lord, may I file my deposit?
Yes, the advocate is not present.
6 na 7.
Six.
Yes, you are for the applicant plaintiff.
Applicant.
Yes. What was the, just show me the last order.
এটা এটা কত আমার মাধবেন্দ্র কুন্ডু এটা এটা মাধবেন্দ্র কুন্ডু
Okay, let me see the report. So you held discussion with the receiver.
last is appointed
Sir,
receiver
sir.
Mr. Koshanko that had expired my lord and there is here is death certificate.
Yes, what do you say?
My lord, may I suggest the petitioner may be authorized on instead of receiver to collect the documents from the bank because the present otherwise the bank documents and other important documents relating to those properties is not traceable.
So,
Bank may
so you obtained regarding your prayer to be appointed as Shebai, that is allowed.
that is allowed.
That is allowed for further anyway. Let the other side appear, let it appear for necessary orders on the next week. You take instructions.
Because my lord, for the last 3 occasions, no one is appearing on behalf of other sides.
No. When the matter application was heard out,
Then my lord, yes.
otherwise the special officer can continue as a receiver. What is the difficulty? So let the other side come on the next week. Let me pass necessary orders. Yes, record an order. Learned advocate for the applicant plaintiff and learned special officer are present. Let the report filed by the learned special office, learned advocate for the applicant, plaintiff and learned special officer are present. Learned special officer files report. Let the same be kept with the record. Let this matter appear on 3/11/2025 for necessary orders. The learned advocate for the other side be intimated.
Item number 7. Item number 7.
My lord, I am the receiver in this matter.
Yes, let me see. So-
Mr. Deepak Dev.
Yes. So, have you obtained the necessary papers from the bank?
No. No.
So after you obtain the necessary papers, you will be permitted to withdraw your remuneration. So obtain the necessary papers. Acha, let this matter appear on 10/11/2025 under the same heading. Learned receiver is permitted to take necessary steps.
নামটা কাগজটা দিন।
My lord, I am appearing in the instant matter on behalf of the legal layer. The background of the matter is that one
Any
part.
application is to be disposed of in this.
No, I am praying for dismissal of the entire probate matter because I was never notified and a purported will was executed by the family priest.
Question is, for that, did you take out any formal application for revocation of the grant?
I am not a party in the probate proceeding. I was never notified.
Very well. Any party can make that application for revocation.
My
Okay.
that in audience, that oral prayer can be made.
No,
my lord.
how parties should be given. Definitely, some application was there.
No, the Honorable Appeal Court recalled the probate order
Let
and
me
there
see,
was a direction to issue citation that was not done
let
for
me
last
see.
15 years.
Let me see this order. So
My
what
lord
was the
has-
order? What was the order passed by the appeal court?
May I hand over?
Yes,
May I hand
yes.
May I be permitted to hand over?
Okay, this is the report of the registrar.
15 years, no step has been taken in respect of a purported will. Probate is recalled. Kindly see the honor.
See the order. Appeal court.
Kindly see the Honorable Appeal Court's order. Beneficiary deputy.
You are representing whom?
I am representing, I was the appellant, I am the legal heir.
You are the appellant, that is
Monica Mondol.
Monica Mondol.
I am the legal heir. I was never notified while the probate was granted. That's why I preferred an appeal and appeal court recalled the probate order. Now, my lord, I
So
have.
the applicant was not represented before the appeal court. The applicant.
Yes.
So it was ex parte anyway.
Yes. Now, my lord, I have, it has come up at my instance before your lordship. I have I have issued notice to the learned advocate that may be in the record. They are not interested to proceed further with the PLA matter, probate matter.
Let me see the
I am
report of the
praying for
registrar.
dismissal, my lord. Subject to my lord's approval, it is no point of keeping the probate application pending further since no citation has been issued till date. 2002 PLA matter. 23 years have passed.
You see, the department has stated that due to non-communication of the order, citation could not be issued. Non-communication of the order of the appeal court, the citation could not be issued. This is the report of the department, registrar.
I have communicated.
No, they're saying they did not have any knowledge with regard to the order. Anyway, let steps be taken by the department. Yes, record an order.
I have communicated, my lord. Kindly see.
The report is stating that they did
Well,
not
the
have any
report is not sacrosanct. My
Yes,
document.
learned advocate for
Sir,
the
kindly see the received copy is there. I have communicated.
they have they
Kindly
stated
see, kindly see this.
anyway it has not gone to the department, whatever it is.
I have communicated. That is there. They have received it.
Yes, so let them take steps. It is for their
Well,
latches.
after 23 years.
It is for their latches, you see. This could not be done. Learned advocate for the applicant is present upon perusal of the report of
Not
the
applicant, my
register
lord.
original. Yes,
Not applicant. I am the legal heir. No application is pending.
no, you have intervened. Definitely you have
Yes,
intervened
yes.
by way of application.
Yes, yes.
Learned advocate for the intervener is present. Upon perusal of the report of the register original site, it appears that due to lack of knowledge of the order dated 8th May 2013 passed by the Honorable Division Bench, steps could not be taken for issuance of citation. Although learned advocate furnishes a copy that the said order was communicated, but in the interest of justice, the department should be directed to issue the citation upon MS Monica Mondol. Thus, steps be taken by the department in terms of the order dated 8th May 2013 passed by the Honorable Appeal Court, and report be submitted on or before 1/12/2025. Let this matter appear on 1/12/2025 under the same heading.
My lord, kindly keep it on after 4th.
Hmm?
Kindly keep it
After?
after 4th December.
Okay. Let this matter appear on 8/12/2025 under the same heading.
I am grateful.
কোনটা ওটা আছে May 8th 2013 acha register original side is requested to ensure that steps are taken with regard to issuance of citation.
I am grateful.
Is requested to ensure.
কমিউনিকেশন লেটারটা তো রেকর্ড করেছে কমিউনিকেশনাল লেটারটা রেকর্ড করেছে
Wait, please, ma'am.
No, today the matter is appearing at my instance, my lord.
Yes.
On my mentioning I had made, my lord was pleased to fix the matter, my lord. However, my lord, the senior engaged Mr. Devnath Ghosh had some personal difficulty on that day. I had mentioned the matter upon notice to my learned friend. My lord was then pleased to fix.
So when this matter should appear?
If my lord could kindly fix the matter any day post the 10th at a specific time, my lord.
That means any matter except 10th of November.
Any day after the 10th of November.
Yes, record an order.
Lordship, one indulgence.
Yes.
Lordship, I am not opposing the request for adjournment today. However, my lord, in December, 2 years of the witness action of my of the plaintiff is going to be completed. Lordship, there was a peremptory direction as per your lordship's last order. May that continue, your lordship.
Relax, God.
Yes, learned advocates for the parties are present. The matter is pending witness examination
Yes, my lord.
of PW
One, your
One.
lordship.
PW1. By consent of the parties, the matter be fixed on 11 তারিখে দেখুন তো কোনো ফিক্সড আছে কি?
Could it be the 12th, my lord? Could it be the 12th, my lord?
আচ্ছা 12 তারিখে? তাহলে 13 তারিখ হতে পারে। Yes, 13/11/2025 at 3 p.m.
Very well, lordship. Brief.
Obliged.
Witness action.
But I appeal for the plaintiff. Well,
For
today
the-
your
I appeal
lordship
for
had
the
fixed
defendant.
the matter for ascertaining the result of the mediation. But the mediation was a
Mediator
non,
has submitted the report.
but not to our knowledge, my lord.
Let me
But
see.
in any event, my lord, the
No,
mediation.
today, if the date is fixed for mediator's report, I have to see the report.
Yes, my lord, but the mediation was a non-starter because my learned friend's client did not participate in it.
My lord, what happened, my lord, on that
With the
day,
Acha.
I was stuck before the Honorable Justice Orindam Mukherjee.
No,
and could not
mediations
able to-
are held after quota was probably.
Yes,
That's but
4:30.
it was the date was the time was given at 4 p.m. That's why I'm not able to attend that meeting.
Anyway, so
But
that
but
the mediator
whatever the thing
extends the
is,
time.
the matter can be
Anyway, mediation has not concluded.
My lord, no, my lord, your
That has been
lordship, the
dropped, my lord.
mediator has dropped the proceedings because it was a
there
non-starter.
is
Because
a
there were
chance
two
for
occasions
settlement, my lord.
given,
That
my lord.
I can assure your lordship.
Two opportunities given, my lord, the defendants did not participate.
My lord, there is a chance for settlement, my lord. That I can assure your lordship, my lord. It's my prayer only, my lord. Give me a chance for.
So if both of you agree, I can.
But I
see
have
once
no
more.
objection, my lord. My clients will.
Yes, record an order. Learned advocates for the parties are present. Although the mediation proceedings failed on the
Drop,
last
my lord.
occasion.
But
due
it would
to-
be a non-starter, my lord. Because there was
no,
opportunity.
mediation proceedings could not be commenced.
Great.
As although mediation proceedings could not be commenced on the last occasion due to failure of the defendant to appear before the mediator, but as the learned advocate for the mediator submits that this time
Not mediator, my lord, but for defendant.
learned advocate for the defendant
Defend.
submits that his client this time will not fail to appear before the
Lordship.
his client will not fail this time to appear before the learned mediator. This time the matter is once again referred to mediation. Parties shall appear before the mediator on the date and time fixed by him. Let this matter, let a copy of this order be sent to order. On the last occasion, did the court appoint any mediator?
Yes. Your lordship had appointed, my lord, an ex-judge of this honorable court, my lord.
Who was appointed?
Justice Ashok Das.
Ashok Das.
Okay.
Retired.
আচ্ছা ওর আগে ডেট পরে লাগে আচ্ছা The Honorable Justice Ashok Das Adhikari, former judge of this court, is appointed as mediator for settlement of the dispute. Let a copy of this order be sent to the Secretary Mediation Committee by the department. Fix 1/12/2025 for report of the learned mediator.
Can it be possible to shift this on January, my lord?
No, why? Let us see. On
Well, let a
1/12.
report come, my lord.
Very
If my learned
very
friends do not participate
I'm
again,
keeping
my
it
lord.
1 month time, 1/12.
Very good.
1/12/2025 for report of the mediator.
But may be kept on 4th, my lord. There's some personal
Okay,
difficulty
4th.
at first.
4/12/2025 for report of the mediator. Let this matter appear on 4/12/2025 at 4 p.m.
Grateful.
Deeply.
Grateful.
Enough.
Yes, not today.
Item number 12, my lord. This is my application for, my lord, appointment of a receiver in respect of a property, my lord.
So GA 14 is to be heard out.
Yes, my lord. That's, my lord,
All
the present
parties
application.
are present.
All the parties are present.
Yes. Affidavits are complete.
My lord, no, my lord, I'm praying for an ad interim order.
I'm praying for direction of
But let me, my lord, place my case, my lord.
Notice
Your
of
lordship, kindly, my lord, hears me out. But before your lordship, my lord, opens the papers, my lord, I'll just, my lord, indicate, my lord, that what are, my lord, the brief facts of this matter. It has got a checkered history, my lord. The suit has been continuing since long, my lord, since 1998. And, my lord, receivers have been appointed, my lord, in this matter, my lord, to oversee, my lord, the subject property, which is, my lord, the suit property. My lord, the respondent number 1, which is, my lord, the defendant number 1, is the owner of, my lord, premises number 41A AJC Bose Road. So, a premises in 41A AJC Bose Road. Now, my lord, I'll come to that. I'll come to that. My lord, I'll come to that. My lord, my learned friend need not, my lord, continuously, my lord,
yes, you will get a
interrupt.
chance.
I'll
File your
get a
affidavit.
chance, Lord, of course. The respondent number 1, my lord, defendant number 1, had executed an agreement for lease on, my lord, 19th of March 1997 in favor of, my lord, the plaintiff, which is where, my lord, the cause of action arises. My lord, thereafter, my lord, the plaintiff paid the entire consideration of, my lord, the lease agreement of, my lord, 77 lakhs and not. My lord, due to, my lord, breaches committed by, my lord, the respondent number 1, who's been represented by my learned friend, my lord, the suit was filed for specific performance of that agreement for lease. Initially, my lord, there was an order of injunction, my lord, passed in, my lord, 11th of, my lord, February 1998, my lord, not to, my lord, alienate, my lord, the property, my lord, or create any third-party rights. My lord, the suit property, interestingly, is not the entirety of, my lord, the building. It is, my lord, 8,000 square feet on the 4th floor on
That is
the
the
southern
suit property.
That is the suit property. So, not 41A AJC Bose Road, the entirety of the building, but on the 4th floor, 8,000 square feet on the southern portion of the 4th floor. So, my lord, after that, my lord, an injunction order was passed on, my lord, the suit property, which is the 8,000 square feet on the 4th floor, not to create any third-party rights. Appeal was preferred, appeal was dismissed. Thereafter, my learned friend, my lord, who just interrupted, my lord, had filed an application on behalf of, my lord, Siddharth Fabricators Private Limited. My lord, they filed an application alleging that, my lord, they had purchased, my lord, the entire building at 41A AJC Bose Road, except the 8,000 square feet. But interestingly, my lord, if your lordship now, my lord, takes, my lord, their application for addition of party, where they themselves admit that the 8,000 square feet on the 4th floor, which is the subject matter of
They
the
were
suit
added
property,
as party.
they were added as a party,
Yes.
but with the condition that they would be there in the suit as a, if I may use the expression, my lord, kindly, my lord, pardon my, my lord, terminology, as a watchdog. As a watchdog to, my lord, only oversee whether the suit for specific performance is not being granted in respect of any other portions of the building apart from the 8,000 square feet on the 4th floor. So, my lord, they are the owner of the building except that 8,000 square feet, which I want to show from your lordship, my lord, their application. If your lordship, my lord, now kindly turns to, my lord, page 99, which is their application. So it is not my contention, but it is their contention that they are owner of the entire building except that 8,000 square feet. But the application starts at page 99. At page 102, your lordship will find at paragraph 7. At page 102, paragraph 7, the petitioner states that the petitioner nominated one Skylark India Private Limited, who in turn nominated one Alcove Construction Private Limited for purchase of the said property by a deed of conveyance dated 23rd November 2006. The entire property of 41A Acharya Jagadish Chandra Bose Road, except the 8,000 square feet on the 4th floor, was conveyed to Alcove Construction Private Limited for a consideration of such and such. Then thereafter, the said 8,000 square feet of space on the 4th floor was not conveyed or transferred only by reason of orders of this honorable court dated, which is the injunction order which is prevailing in this suit, 11th February 1998, and the order of the Debt Recovery Tribunal dated 29th May 2006, which is a separate proceeding. Now, my lord, admittedly, so my lord, their own admission that my lord, the entire property was purchased except the 8,000 square feet, which is the subject matter of suit property. So, my lord, they have nothing to say with respect to this now. Now, my lord, they were added, interestingly, with a condition that they will not prejudice the rights of the other defendants. If your lordship kindly takes, my lord, the order of adding them as parties, page 113 of my lord, my application.
The question is there any scope to pass any interim order?
My lord, the receiver, my lord, which my lord needs to be my lord appointed now.
Yes.
Because I'll tell your lordship why. My lord, the defendant number 1 on my lord 28th of my lord, I'm sorry, my lord, on my lord 10th of my lord December 2015 had my lord conceded to my lord to a decree in this suit. Defendant number 1, who is the admittedly who is the owner of the 8,000 square feet on the 4th floor, conceded to the decree. But thereafter, till date, the decree could not have been passed because, my lord, of various reasons, which, my lord, the defendant number 2, the added party, is my lord, interrupting, my lord, interfering. Now, my lord, if your lordship kindly straight away takes, my lord, page 193.
Second volume.
Yes, my lord, page 193. First volume, second volume. Second volume.
Yes.
Your lordship will find, my lord, this, my lord, is the suit property, where, my lord, your lordship will find a key, a lock, a padlock, and the door being sealed over there. Now, my lord, defendant number 1 has, my lord, conceded to a decree in this suit. The defendant, the added defendant, has got no right, title, or interest in respect of this 8,000 square feet. So, my lord, whose lock, padlock is there sealing the suit property, subject property? My lord, why, my lord, a receiver is required is, my lord, for preservation of, my lord, the subject property of the suit. That's, my lord, a settled principle. Now, if, my lord, the subject property is frittered away, given to third parties, then, my lord, I get a paper decree. I don't get, my lord, I cannot enjoy the usufructs of, my lord, the decree. And, my lord, interestingly, it's not that, my lord, the receiver was not appointed in this suit, my lord. If your lordship, my lord, kindly takes, my lord, page 124, receiver was appointed in this suit in a previous application. Kindly see, my lord, page 124, an order pursuant to which the receiver has submitted a report, done an inventory. But thereafter, my lord, subsequently, this new facts have, my lord, come up. Kindly see, my lord, page 124. GH such and such is an application with prayers for appointment of a receiver or special officer to make a detailed inventory of the entire area of the 4th floor, being such and such, including the 8,000 square feet. And kindly, my lord, turns over the page. My lord, page 126, your lordship will find, my lord, the last paragraph, such and such, learned advocate is appointed as a special officer to make an inventory in premises number such and such of the space referred to in such and such 2G of the plaintiff introducing Schedule A thereto and the said schedule. The special officer will notify his convenience such and such, and thereafter will file a report. My lord, pursuant to which, my lord, they had filed a report. Your lordship will find, my lord, I have also annexed a copy of the report, which is at page 132.
Yes.
Kindly takes, my lord, page 134 of the report, paragraph 10. Your lordship will find from the 4th floor plan, it is also evident that a portion out of the total 8,000 square feet vacant area, kindly marks this. So, my lord, the photograph does not show it's a vacant area. It's now under lock and seal. It's a padlock is there and the doors are sealed.
No.
On northeastern side.
Maybe under sill. A vacant area may also be under sill.
It may be there. But if, my lord, somebody is
Somebody has
occupying
taken.
or somebody is, my lord, trying to forcefully enter into, my lord, the suit property, it is, my lord, my duty to come up before your lordship, my lord, so that the estate can be, my lord, preserved. The subject property of the suit can be preserved, which has to be found to be vacant by physical verification and also falls in the southern portion if taken in totality. So, my lord, a report has been filed to that effect. Now, my lord, interestingly, my lord, we, my lord, sought for a clarification that please specify that which portion you are talking about is vacant and which portion is the 8,000 square feet. That, my lord, order was passed. A clarification order was passed. My lord, if your lordship kindly takes, my lord, page 187, which is, my lord, in the second volume again, my lord.
Yes.
Your lordship will find, my lord, that paragraph 10 had been reproduced. And, my lord, we sought for a clarification that what is the vacant space which has been referred to by the learned special officer, which is annexed to the report. At 188, my lord, we sought for that clarification. And, my lord, at page 189, a supplementary report was filed by the learned special officer. If your lordship kindly looks at, my lord, paragraph 6 at page 190. Further, in the event the entire floor is divided into two halves, as southern and northern half, by drawing the 8,000 square feet. One, that this the added party was added with a condition. If your lordship kindly takes page 114. So how much they can talk about the suit property today, or how much they can oppose this application, it will be clear to your lordship. Kindly takes page 113. The last paragraph, the typed copy is at 114. It is
yes.
Your lordship kindly takes the typed copy, page 114. The last paragraph, the order, however, this is an order, but adding them as a party. The order, however, shall not cause any prejudice to the rights of any of the other defendants in any manner, which shall be adjudicated at the time of final hearing of the suit. So, my lord, they have been, in my respectful submission, been added only to watch whether anything else is being conveyed, or a specific performance decree is being
regarding the 8,000 which is under padlock.
They have nothing.
Did they claim any right in that in their petition?
No. 8,000 square feet is clear. On the 4th floor, 8,000 square feet is very clear. They cannot have any either let the learned special officer go, inspect, file a report initially before your lordship passes an order for taking physical possession of the property. Let him come back and file a report to that effect, that what is it that is under padlock and seal. That is all that I am beseeching your lordship. But in this aspect, your lordship may also kindly see that they have nothing to say with regard to this 8,000 square feet is also there. The learned special officer, while filing the previous report, had also annexed the deed of conveyance by which the added defendant had purchased the building. That also says that 8,000 square feet is left aside. If your lordship kindly sees, the deed starts at, if your lordship kindly takes page 162, the schedule of the deed. That's in the second volume. Page 162.
Yes.
Your lordship will find the schedule, the first schedule. Kindly takes the last, however, excepting, however. Did your lordship find it? Except, however, 8,000 square feet of the area on the 4th floor of the said building of the said premises, which is shown in such and such.
So, according to you, this portion is under lock and key.
Yes, my lord.
Entire portion
The 8,000 square
or
feet.
part of the 8,000.
No, my lord, the entire 8,000. We cannot
Entire
enter
8,000.
into. Yes, my lord. We cannot enter into that 8,000 square feet. And my lord, I would only rely on a judgment of the Honorable Supreme Court. I know at interim stage is not required, my lord, but if your lordship kindly takes one judgment, which only says that Order 40 Rule 1, where a receiver or a special officer for doing a specific task, in this case taken an inventory and taking over physical possession, needs to preserve the subject matter of the suit, which is why the Order 40 Rule 1 or provisions like Order 39.
There is an interim order of injunction also.
Injunction is already present. Despite that, all this is happening. Your lordship kindly takes. My lord, 2015-12 SCC 192. এটা দিয়ে দেবেন একটু para 13, my lord. I'll not trouble your lordship by going through the entirety of the paragraph, my lord, which says that it needs to be preserved. The property needs to, the first two lines itself. Paragraph 13, the penultimate paragraph. A receiver is appointed pending suit or the appeal. The prime objective is to preserve the property by taking possession or otherwise. So if the property is not preserved, despite the injunction being there, but I'll be rendered remediless. Those are my respectful submissions. Let them reply to this.
Yes, so all the defendants are appearing.
Yes, my lord.
Therefore,
I appear on behalf of defendant number 1, my lord.
yes, what is your submission?
My lord, in so far as the instant property is concerned, we stick by what submissions we had made in the order dated 10th December 2015. We can't retract from that, neither can we advance any further submissions in respect of that.
10th December 2015 is the order where by which the defendant number 1 had conceded to get a decree of specific performance. So they agreed to submit to a decree.
Yes, for
Page
defendant number
121. If you
You are for Amrita Bajar
Yes, my
Putrika.
lord, because the whole crux is, my lord, we don't have the money to pay back the plaintiff.
So you conceded to the
Yes,
prayer
my lord,
of
because we had received an amount of 77 lakhs. Along with interest, whatever the amount comes today, we don't have the money to pay back. In any event, we are a company which has gone into bankruptcy. We don't have any money. There are huge dues. So we are not in a position today, my lord, to pay back the money. So that's why we had considered to a decree in 2015 itself.
Your lordship kindly takes the order, page 121. Lordship will find at page 122. May I just read it for your lordship? Submits that there being a suit for specific performance of an agreement dated such and such, the subject matter of which is the property in suit, his client having had received the agreed consideration
page
is willing to.
122.
121 it starts at 122,
Yes.
121 if your lordship kindly takes, 121. Last two lines, submits this. This is a submission of the defendant number 1. Your lordship will find Mr. Shah, learned senior advocate, appearing on behalf of the defendant number 1. submits that this being a suit for specific performance of an agreement dated such and such, the subject matter of which is the property in suit, his client, having had received the agreed consideration, is willing to submit to a decree as claimed by the plaintiff. Mr. Shah submitted that this is an admission made otherwise than in the pleadings, which the court should take cognizance of, and without waiting for the determination of any other questions between the parties, give judgment accordingly. Despite that, my lord, due to, my lord, the diligent efforts of, my lord, the added defendant, my lord, the suit has been kept pending.
So your grievance is somebody, that means steps are being taken. There is to interfere in the suit property.
Yes, my lord, which needs to be preserved.
And regarding that padlock, it is not known to anybody.
Not known to who has put the padlock. If the defendant, the added defendant, says that they have put the padlock, then it's something else. Then they have to be that there has to be a receiver who should take the physical possession of one of the suit property. And if they say it's not their padlock, then, my lord,
yes,
I appear for the defendant number 2.
Added defendant.
My lord.
Yes.
Now, my lord, is a regular defendant. Added subsequently. My lord, with respect, I'll come to all the points which my learned friend has just raised. My lord, 90% of the facts have not been stated before your lordship. At least 90%. My lord has to know what the suit is. I have couple of points, my lord. I'll try to assist your lordship. If my client can, he will try to demonstrate that this is a total abuse in collusion with each other by defendant number 1 and the plaintiff. Total abuse of the powers. My lord, kindly seize the cause title once. There's a defendant number 3 also.
So defendant number 3 is the pro forma defendant.
They have made them pro forma defendant.
You are not claiming any relief.
It's a suit for specific performance
Okay.
between two parties. My
lord, defendant number 3 was erstwhile United Bank of India, who was the charge holder of the entire assets of the defendant number 1. Mortgaged. With the promulgation of the Debt Recovery Tribunal Act, the matters were transferred. Defendant number 1 went into liquidation also at one point of time. The proceedings before the recovery officer was in progress. Asset sale committee was appointed for the purpose of selling the assets of defendant number 1. That asset sale committee has sold the property because of the subsisting order of injunction obtained by the plaintiff in respect of the portion which my learned friend has contended. Entire properties have been sold. And the sale proceeds are held by asset sale committee, the bank. And it's required to be distributed in the manner provided in the order of the appointment and disbursement with regard to the money. That was passed by the Debt Recovery Tribunal. My lord, I am the successful purchaser of that property before the asset sale committee.
Is it the subsequent event pursuant to your being added as a party?
What?
Or when you were added as a party, these were there? When you were added as a party, were these grounds taken for addition? What you are pleading now?
Yes. My lord, these were the grounds and appeal court has upheld my addition. That is not a problem. My addition is not in dispute.
Yes, yes.
Today a different picture is being presented. I have filed my written statement. The suit is ready for hearing. When the trial was to commence, both these parties, plaintiff and defendant number 1, colluded with each other so that no witness can
file your affidavit in opposition.
I want to, my lord.
Yes,
That's
yes.
the whole purpose. Kindly
Record an
give me
order.
opportunity.
One thing.
No, my lord,
But-
if more submissions, then I'll also have to.
Yes.
But today, my learned friend will not be prejudiced in any manner.
Extremely.
If
extremely.
receiver goes
His
and
suit is
takes
maintainable.
inventory,
Order.
inventory of
Learned
who is
advocate-
there.
Learned advocates for the parties are present.
Whether
Are learned
he has put a
advocates.
padlock or seal.
This is an application for appointment of receiver of the suit property. It is the submission of the learned advocate for the plaintiff that in spite of the order of injunction, there is some interference in the possession of the suit property, and somebody has put a padlock on the suit property without any rhyme or reason. Learned advocate for defendant number 2 submits that many facts are not disclosed in this petition, which is to be disclosed by way of affidavit. Thus, this matter is required to be decided on affidavits. Let affidavit in opposition be filed by 2 weeks. Reply, if
My lord,
any.
kindly, it's a huge proceeding of last, my lord, at least.
My lord, I'll
I
tell you,
can
Lordship,
say-
my lord, by
Okay,
that
3
time, my
weeks.
lord, the suit property
Three
will
weeks,
be treated.
reply,
Yes.
reply, if any, within 1 week thereafter.
Let my lord, the special officer go ahead. please
Let
find-
this
do it.
matter appear on 1/12/2025. However, considering the facts of the case, this court is also of the view that in the meantime, an inspection is required by a learned special officer. Thus, I appoint Dash as the learned special officer to cause inspection of the suit property and ascertain as to who has put the padlock, ascertain who has put the padlock, and if the suit property is being occupied by any persons, if any. In the event, this learned special officer is also permitted to take steps to break open the padlock and see as to whether any articles are there in the suit property, which is claimed to be vacant. Learned special officer shall, upon notice to both all the parties and their learned advocates, cause inspection within a period of 2 weeks and submit report on or before 1/12/2025. Let this matter appear on 1/12/2025 for report of the special officer and hearing of this application.
I'm grateful. I'm grateful.
My lord, without prejudice to my client's right, my lord, kindly provide.
This order is without prejudice to the rights of the parties in this application.
I'm grateful.
Including that, my lord, the application and suit both are not maintained.
That is a different issue. You take it in your affidavit.
My lord, your
Take-
lordship has not given me opportunity
No,
to
no, in your
demonstrate.
affidavit. I have not disposed this application.
No, but ad interim, my lord is
No,
granting.
no, very well. It is necessary at this stage.
I'm grateful.
My lord, the cost has to be borne by the
Yes,
plaintiff.
yes, definitely.
course.
Their petition.
Lordship has not fixed, my lord, any remuneration, my lord. Your lordship will fix it up.
Yeah, I shall fix it.
I'm grateful.
Obliged.
Not today. Yes,
The
14.
plaintiff now-
What was the matter was taken up on the last occasion.
Yes, they have,
short pass over, Mr.
special officer filed the report, they have taken an exception to the
Your
report.
lordship, I will be, maybe.
Oh, Mr. Chakraborty is appearing.
Yes.
Okay, let it be not today. Tomorrow I shall take it up. File it tomorrow.
I have not received any copy, my lord, the exception to the report.
I-
The ticket number 1.
Yes, give the copies, please.
I'm giving.
Give the copies to all the parties.
Right now,
I have not received.
Yes, please give all the copies.
Now, I.
Not today হয়েছে।
My lord, I'm appearing on behalf of the petitioner. This application GA 251, lordship, is an application in nature of pro inter se suo. Now, the difficulty is, lordship, the matter was due to appear on 12th of November. And affidavits
Let
are
it
not.
appear when all the matters will be appear.
It was directed by my lord to appear together with all the other matters.
Let this matter appear on 12/11/2025. 15, you are appearing for 16 also?
No, no, no. Only 15.
Yes, let it appear on 12/11/2025. Okay, let other matters also appear on 12/11.
16, your lordship, I'm appearing on behalf of the joint receiver. I'm only praying for leave for the sale of the property, subject property on as
Let it appear on 12/11 because other matters analogously are being heard on that day.
Okay.
16 also, okay, same order on 12/11.
Then all the matters.
17,
18, 19. all.
18 and 19, yes. Same order, let this matter appears on 12/11/2025.
Because there is a chance, well, after
Reshuffling of the
Okay, let us see.
বলছে না
And for the defendant number 3, Your Lordship, and for the defendant number 1, the talks of settlement is going on, Your Lordship.
Right.
Other matters have been kept on the 1st of December. If this matter may also be kindly kept on the 1st of December, Your
So
Lordship.
1st of December, the other matter is adjourned. Last.
It
Got
was
for?
kept yesterday.
The receiver, my lord, I'm seeking for my discharge. On 7 different occasions, my lord, I've been seeking for my discharge. Kindly, my lord, there have been directions for payment to be made to me by the plaintiff. In the event the plaintiff is not mine.
So why you are who is appearing for the plaintiff?
I appear for the
So why have you not paid the receiver?
My lord, instructions is, my lord, are that he will be paid, my lord, at the earliest, my lord. My lord,
No,
there are
no.
some-
Why this type of attitude? You see, a receiver has discharged the duty and you have kept his remuneration pending.
The duty has not been discharged. my
Possibly, my lord, the duty has not been discharged. I shall indicate why. There was an order passed upon me to take inspection, surprise inspections, and the fund to be and the monies to be paid from a joint fund of in the suit property. My lord. Possibly, my lord, the learned judge that was yes, the learned judge that was sitting, my lord's predecessor in interest was not rightly guided that there was no joint fund. As such, my lord, such fact was mentioned before the honorable court. The honorable court then said no need to undertake your duties because there was joint talks of settlement going on between the parties. However, the honorable court directed that the monies be paid out. There were 4 parties.
No, but you are not discharged.
No, my lord, I was not discharged.
Because you were appointed. Okay. So your appointment was kept.
Yes,
pending.
at
Your
update.
appointment was kept intact. In the meantime, if the talks of settlement fails, then only you will be discharged.
Yes. And then there are 4 parties involved. My lord. 3 out of the 4 parties have paid their proportionate share of the remuneration because that was the direction passed by Honorable Shugato Mujumdar as he then.
Yes, record and order. Learned advocates for the parties and learned receiver is present. Although the parties other than the plaintiff has paid their share of remuneration to the receiver, but the plaintiff has not paid the same. Let the payment be made to the learned receiver forthwith. Let this matter appear on. When did I fix the other matter?
1st of December.
1/12/2025. Yes, please.
Yes, I shall.
Grateful, Lordship.
Lordship, I appear for the petition. I'm led by Mr. Devdut Mukherjee. He is on his legs in courtroom number 38.
Okay, not today.
My lord, may I indicate, my lord, in this matter, I think my learned friend will agree, my lord, in this matter, your lordship had directed us to take instructions from our client whether we are ready for mediation in this matter.
Yes.
So my client.
We did not want to go for a
No,
mediation, Lordship.
there was an order that to take instructions. So my client is ready for mediation. My
Lordship, we don't want to go for a mediation because this has come back after going to 3 special referee, your lordship.
Okay, let it be not today. Come tomorrow.
My lord, may kindly
Lordship,
records an order. Kindly records an order.
Come tomorrow in the presence of the other side.
My lord, my other side is present. My lord, kindly records an order, my lord, so that.
Lordship, may kindly make it not today.
I'm making it not today. Okay. If both parties don't agree, I can't send to mediation.
This matter your lordship can dispose of, my lord. Here, my lord, there is an interim order, my lord, which I am enjoying, my lord. My lord, the only defendant who has filed.
The plaintiff.
I am for the plaintiff, my lord. The only defendant, my lord, who has appeared.
Respondent number 5, your lordship.
Yes, my lord. The respondent number 5 is the only defendant, my lord, who has appeared, my lord. What I tell you, your lordship, my lord, what is the fact, my lord? My client had purchased a flat. My lord, there was no conveyance, my lord. This was purchased way back in 1990s, my lord. My lord, the property was being enjoyed by my client, my lord. My lord, suddenly we found that one notice was pasted by the Debt Recovery Tribunal, my lord, claiming this to be an asset of one Puspesh Bad, my lord. My lord. Then we had filed a suit, my lord, making all the persons, my lord, if your lordship kindly takes the plaint, my lord, and the cost title first, my lord. My clients are plaintiff number 1 to 5, my lord. They are the legal heirs of the original purchaser, my lord, who expired Mahavir Prasad Taingwala, my lord. Mahavir Prasad Taingwala had purchased the property. When we filed the suit, my lord, he had died, my lord. And that is why all the legal heirs, including his wife, they were the plaintiff. Now, if you also look at the defendants, my lord, R. Sathilan and Company Private Limited, Savitri Devi Singhania, Kevalchand Gandhi, Mehta, Om Prakash Gupta, Usha Kiran Housing Corporation. My lord, they were the owners of the property, and through defendant number 6, my lord, which was the developer, my lord, they constructed the building, my lord.
Yes.
Now, my lord, originally, my lord, the flat was purchased from the owner and developer, my lord, by defendant number 7 and 8, my lord, who are Indra Kumar and Khurshid Shah.
Now, what is the present stage?
My lord, I'll tell you. Your Lordship, can you give me 2 minutes time?
Which
so that
application?
it is my injunction application, my lord. But I'm enjoying interim order so that my property cannot be sold.
So interim order. What is the interim order?
Interim order.
What is the order?
My lord, the first order was passed, my lord, by Justice I.P. Mukherjee, my lord. But if your Lordship have that order sheet with your Lordship.
Dekhi order ta dekhi. Last order.
That was an order of 8th August 2012, my lord.
Oh, last right. 10th September also interim order was extended.
Yes, well, your Lordship was kind enough to extend the interim order, my lord. These I'm enjoying. In fact, joint receivers.
When it was passed.
First, it was passed on 8th August 2012. My lord.
So thereafter, did they file the affidavits?
Only one defendant came forward, my lord, and filed affidavit. My lord, who is the main defendant, my lord?
So that affidavit is to be considered if this order is.
If your Lordship now takes the affidavit.
No, you see, the other side is not ready. Are you ready with the matter? To do the matter?
Your Lordship, we've already filed the affidavit, Your Lordship. There's only one.
So have you filed your reply also?
No, there's no need to. If your Lordship can takes up his affidavit, my lord.
Yes, let me see the affidavit.
Yes, my lord. Your Lordship will see the affidavit. Opposition. Lord, it is a very small affidavit. If your Lordship straight away comes to paragraph 6.
Santilal and Company.
My lord, your Lordship will see I am reading the affidavit, my lord. My learned friend's affidavit, my lord. I am the respondent number 5, page 5, my lord.
Yes.
Now, paragraph 5, my lord, in fact 6. With reference to paragraph 2 to such and such, I say that save matters of record under reference denied. I say, your Lordship will kindly see, I say, but in fact, a decree on judgment on admission can be passed. I say that the said flat forming subject matter of the petition could not have been mortgaged to the respondent number 12, who is the bank, my lord, by the respondent number 9 as a guarantor of the respondent number 10, as has been alleged in the impugned demand notice dated 12 July 2012, published in the Times of India, dated July 8, 2012, under the provisions of Sarfasi Act. Now, your Lordship will see, my lord. I say.
Anyway, I am not going into that because you did not take out any application for judgment on admission.
I have not taken out.
So I am going into that. Anyway, what was the interim relief you sought for in the injunction?
Well, injunction was there, my lord.
Let me see the order, original order of injunction.
If your Lordship don't have, my lord, I can give a copy here, my lord. 8th August.
What is order?
Well, I am giving a copy to my lord.
Yes.
8th August is the order of 2012, my lord. Let one more note, my lord, one counsel had appeared earlier, my lord, for defendant 5 again. Affidavit service on record, apart from Mr. Mitra representing the 5th defendant.
Question is it under a receiver also?
Yes, my lord. They are joint receivers, my lord, who are in possession, my lord.
Okay.
My lord. You know, will see, the case of the plaintiff is that they are in possession of the flat number 4B on the 4th floor, Kamak Street, along with the car parking space and servants' quarter. They are in occupation of the flats from 1990, when the father of the 2nd to 5th plaintiff purchased that property from the 7th and 8th defendants. The purchase was by way of an agreement of sale dated 18th April 1990, coupled with possession and payment of the entire consideration. Now, the State Bank of India threatens to dispurchase the plaintiff from this property by a demand notice under Sarfasi Act. In the notice, the 9th defendant is shown as the guarantor, and the above flat is included in the description of security. In the agreement falls referred to in
Nobody appeared for the bank authority.
No, my lord, nobody is out. Now, your lordship will see, in the meantime, the property has to be protected. On the above facts, I appoint Sujit Chatterjee, Songita Rai, advocate, as joint receivers at a remuneration of 500 each to be paid by the plaintiff to take symbolic possession. My lord, they are in symbolic possession and they have put their keys, my lord, of the flat after making an inventory. My lord, we have got the report also. If your lordship kindly takes up the report, my lord, they have filed a report also. I don't know whether that report is there before my lord.
Anyway, so when this order was passed, only defendant number 5 was represented.
My lord.
You are for defendant number 1.
Five. She's appearing. Defendant 5. No, he is the principal defendant. My lord, the conveyance, if your lordship looks at the conveyance, the so-called
number 5 means, you see, okay, that is
Om Prakash Gupta.
Om Prakash Gupta.
My lord, I will
the allegation was against the bank authorities. Main allegation.
But my lord, your lordship will see, the bank had claimed title pursuant to a deed of conveyance, my lord, allegedly signed by Om Prakash Gupta. My lord, in his affidavit, he says, I have not signed that affidavit. I have not signed any conveyance.
Anyway, you come with necessary application. I'm
very well.
I'm making this absolute.
Your lordship can you confirm the interim order?
Learned advocate for the plaintiff petitioner and learned advocate for the defendant number 5 are present. Hard learned advocates. Learned advocate for the plaintiff petitioner submits that the interim order granted on 8th August 2012 be confirmed and made absolute. Stop. Upon perusing the affidavit of defendant number 5 and considering the nature of the suit and the interim order passed earlier on 8th August 2012, this court is of the view that for the purpose of preserving the suit property and considering the balance of convenience and the irreparable loss, the interim order should be made absolute. Thus, the interim order passed on 8th August 2012 is made absolute till the disposal of the suit.
But I shall take out necessary. You also can provide me liberty if necessary, not.
Yes. So service upon all the defendants are complete.
They have not. None of them is traceable. I have got a certificate.
If you have not traceable, you have to take steps.
We have taken a step. We have taken a step.
Okay.
Department, your lordship can call the report.
Let a report be submitted by the department as to whether the service of summons is complete with regard to the other defendants.
In the writ of service of writ of summons in the suit, my lord, because that will take care of the intact.
Of all the defendants is
all
complete
the
or not?
My lord, yes.
Let this matter appear on 1/12/2025.
My lord, your lordship will kindly give me some. My son will be getting married, my lord, in first week of December. Your lordship will give at least after. Can it be sometime in January, my lord? Because that way, because I'll be traveling with thereafter, my lord.
Okay.
I will have to take some. My clients are also in Bellary.
Shall I keep it in the end of November or at the 3rd week of December?
Well, I think, my lord, by that time I may not be able to take instruction, my lord. Or November, yes, my lord, 3rd week of November. Yes.
Let this matter appear on 28/11/2025 for report of the department.
Report of the department. That will take care. I am deeply obliged.
Item number 23. Item number 23 to 34, my lord, it was fixed on 23rd of September. But it was not listed by perhaps before the vacation. I was on legs. Kindly keeps it any day. A time fixed. Let it be a time fixed matter.
I was hearing this 16th.
Yes. My lord was hearing me.
Yes.
Yes, my lord. GA16, Mr. Mukherjee appearing for the plaintiff has completed his argument.
Only reply.
I was, arguing, respond number 1 to 4.
Yes, my lord.
My lord, I am appearing on behalf of respondent number 5 to 9. This is my application, my lord. On the last day, Mr. Dasgupta was already making his submission.
Yes,
He has not concluded yet.
Mr. Dasgupta was on legs.
So next week?
Very well.
Millard keeps it any day, Millard. Let it be a time fixed, man. And Millard, any day. It was already 3 p.m. fixed that day.
Advocates for the parties are present. Let this matter appear on আচ্ছা, নভেম্বরের 3 তারিখে ওই 3টের সময় আছে কিছু? 2টোর সময় কি 3টের সময়? দুটোর সময়? Okay. Let this matter appear on 3/11/2025 at 2 p.m.
Very well.
Grateful.
Grateful.
With the other applications. My lord, it's appearing in the list 23 to 34, my lord.
Yes, all 23 to 34, all
20
same.
the applications 34, no?
23 to 34, same order. Let this matter appear on 3/11/2025 at 2 p.m.
Yes, my lord. Grateful, my lord.
Yes, my lord. Grateful, my lord.
Lordship, item number 35, I am appearing on behalf of the plaintiff. Lordship, 35, I am appearing on behalf of the plaintiff, my lord.
Yes, what is this application for?
Lordship, the application I do not want to press, my lord. I want to proceed with the suit. Lordship will kindly bear with me and take the last order passed by your lordship on 28th of August, your lordship. May I
Yes.
read it out, your lordship?
Let me see the order.
Lordship has it. 28th August, lordship. Lordship has got the order.
Yes, sir. Nobody is appearing for the defendant. Okay.
Lordship, for a long time, my lord. I am just praying, lordship.
Today there is a request from the Bar Association not to pass any adverse orders. Okay.
Lordship, may keep it next Monday, my lord, please, kindly.
Not this week. I'm just making it not this week.
Lordship, may it be at the top on Monday, my lord, please.
Acha, let this matter appear on 3/11/2025 at 4 p.m.
Grateful, lordship.
My lord, I'm appearing for the plaintiff respondent in this matter. Your lordship remembers this is a suit claiming damages for defamation. By the order dated 2nd of August, your
There was a
lordship had-
direction to submit a report.
My lord,
Anyway, both the senior counsels, Mr. Ghosh and Mr.
Shakushan was
Mr. Ghosh and
the arguments were over,
Mr.
my lord, and by 2-3 subsequent orders, your lordship had directed the ROC Kolkata to submit the 2009 report, interim report, my lord.
My lord, kindly see the last order of 10th September. My lord has directed the advocate for the parties to communicate this order to the ROC. My lord, we have done so, my lord. My lord, may I just... Thereafter, my lord, we have received a call from the ROC, my lord.
You are for?
For the defendant.
Yes.
We have received a call from the ROC
Yes.
requesting us to provide them a copy of the report. My lord, we have done
Copy of what?
The report, my lord.
The ROC is the investigation report, my lord.
Okay, I'm
based on
just
which they-
adjourning it for 1 week or something.
My lord.
Have you appeared before the ROC with the report?
My lord, there was no investigation. There was an interim finding. This has reached no finality. Your lordship
That
remembers this.
report has to be submitted by the ROC. They wanted a
My
copy
lord.
from you.
My lord.
My lord, we have provided them with the copy, my lord.
What the copy that has been filed along with the application, that was an incomplete copy. Your lordship remembers that one page was missing. That is why they wanted to bring the whole thing on record.
Anyway, record and order. Learned advocates for the parties are present. Today is the date fixed for filing report by the Register of Companies.
This was
As-
the third occasion, my lord. when they
As the report is not filed, time is granted to the said authority to file the report peremptorily on or before 10/11/2025.
So grateful, my
My
lord.
lord, will kindly consider that we have communicated the order to...
Let this matter appear on 10/11/2025. Learned advocates are requested to communicate this order along with the earlier order.
My lord, learned advocates, even of the plaintiff also, or only the defendant, this is their application.
Either of the advocates can
As per
communicate.
last order,
My lord, they were
learned
directed
advocates
on the
are-
last occasion.
My lord,
We have been objecting the application, my lord.
Okay, learned advocate for the defendant. Anyway, learned advocates, anybody
My
can
lord, we'll
communicate the
communicate.
court's order. There is no such bar.
Grateful, my lord.
Yes, Mr. Datto. So today was the date fixed for submission of the report, but it has not come. So I granted them time on or before, without fail, that is on or before 10/11/2025, requesting the learned advocates to communicate once again
Shall once again come.
this order and the earlier orders.
Because without the report, we can't proceed further, my lord.
It's a পড়ে গেল।
Grateful, my lord.
Grateful.
Keeping it on 10th.
Grateful.
Lordship, I appear for the defendant in this matter.
Lord, I am appearing for the plaintiffs.
So you have filed the suggested issues.
Yes, already it is filed and it is with a record.
Your Lordship, a copy of the suggested issues given by the plaintiffs will be served upon us, and on the next occasion, we'll also file our suggested issues.
Yes, record on order.
এক্ষুনি একটাই copy আছে আমি zero.
Learned advocates for the parties are present. As the plaintiffs have filed suggested issues, let the copy of the same be handed over to the learned advocate. Of the suggested issues be handed over to the learned advocate for the defendant. Learned advocate for the defendant is also requested to file the suggested issues on or before 11/11/2025. Let this matter appear on 11/11/2025. Same. 38 also same order. Yes, 38. Have you filed the suggested issues?
Yes,
38.
it is
Oh, same.
Same, it is fine.
Lordship, I beg to appear for the defendant number 1. Mr. Aditya Mondal is appearing in this matter. He has not joined this court.
Okay, plaintiff's advocate is here. Okay, not today.
Lordship, kindly keep the matter after a week.
Okay, not this week.
Much obliged.
Not today. Not today.
41,
Not today.
42. Yes, action.
Not today.
Undefeated suit at number 43.
My lord,
The
I appear for the
43,
plaintiff.
I'm not, I appear for the defendant number 1A, oh, sorry, I'm 1 and 4A, my lord. My lord, this has been placed under the undefended suit, my lord. But yeah, we were taking steps for filing an application for recalling of that order, my lord, and liberty to be given to file written statement. Has been made ready, my lord, but because of this intervening.
No, what is this nature of the suit?
My lord, it's a
Partition
petition suit,
partition
undefeated against all the plaintiffs. My lord, like on 3rd September's direction, my lord, kindly,
My lord,
if my lord considers. My
lord,
lord has specifically
I
kept
know,
it
my lord,
undefended and given the liberty to the defendants to file and take up necessary steps for.
My lord, we were taking that steps, my lord, and
I think,
because of
my lord,
this.
it's a 1987 suit, my lord. Since September, if the defendants has not been able to file any
Just
application,
gives
my
me
lord,
1 week's
they
time, my lord,
can do
we'll
any
be
time.
able to-
My lord, let us proceed with the suit. My lord, kindly allows me to file my judge's brief of documents by within 2 weeks, my lord.
So when was the, you see, 1987, till
Yes,
today
my
you
lord.
did not file the written statement.
My lord,
My lord,
may I just indicate, my lord? May I
Yes.
just indicate? 87 suit.
Yes.
They did not get any interim order. They had prayed for. They did not get any. They got an interim order which was subsequently vacated. If I stand corrected, my lord. Then what happened, my lord? In 2023, my lord, they come up with an application again, my lord, for further interim orders. That was dismissed. Then they started proceeding with the suit till 80 from 87 till.
You are a substituted defendant.
No, my lord.
Yes,
Defendant
my lord.
number 1
That-
also.
My lord,
And
defendant
the
number 1.
substituted defendant, my lord, defendant number 4A.
My lord, with the deepest of respect to my learned
I
senior
am sending it
friend.
to mediation. If mediation,
My lord,
will have to hear
very
it
well.
from
My lord, it will never happen, my lord. 87 suits, I have instructions, it will never happen.
I am
My lord,
ready for
kindly,
the
I
mediation,
have a
my lord.
specific instruction to proceed with the suits, my lord. Kindly allows me to file the judge's brief.
If they come up with a proposal, let them come up outside the court, then we can make a submission. But
Sending
today,
it to mediation is your lordship's discretion, not his.
my lord,
Not his discretion.
it's not about the
his instruction.
discretion, my lord. Kindly considers, my lord, today. 87 suit defendant will try and continuously trying to.
He's a substituted defendant. So anyway,
Yes, my lord, he has not filed a wakalatnama, my lord. I have satisfied, my lord. No,
that is why.
that is the thing, my lord.
Lord, I am
My lord
saying that is why we wanted to take steps. It has been recorded in the 3rd September.
3rd September, my lord. Today we are on October
anyway,
end,
I'm
my lord.
making it not this week. You take if you can file it and take necessary steps within this time, I shall consider.
My lord, they can do it any for the time, my lord. In the
Yes,
meantime,
record an order.
kindly
Learned
grants me
advocate
direction
for
to
the
file my
plaintiff and learned advocate for defendant number 4A are present.
1 and 4A.
My lord, they have no locus today. They have not filed a vakalatnama till date. Someone was served in February, my lord.
In terms of 3rd September, in terms of order dated 3rd September 2025, the matter was directed to appear as undefended suit. However, in the said order, Mr. Gupta was granted liberty to file Vokalatnama.
Yes, ma'am.
And it was specifically observed that with regard to filing of written statement, no order can be passed at this stage. Stop. As the order dated 3rd September 2025 is not challenged in appeal, it has reached
Yes,
its
ma'am.
finality and no further direction with regard to filing of written statement can be passed.
Grateful, my lord.
However, Mr. Gupta is granted leave to file the written statement, file the Vokalatnama on or before 3/11/2025. Let this matter appear on
My lord,
3/11.
the plaintiffs will also be directed to file their judge's brief in the meantime.
No,
They
actually,
can
you
come up,
see,
my lord.
because let this matter appear on 3/11/2025 under the heading undefended suit.
My lord, in the meantime, let us take the steps.
Let me see whether he files Vokalatnama or not.
They will keep on continuing doing this, my lord. Kindly gives me the liberty to
Because
file my
if you
judge's
see,
brief.
if he
That
does
will
not, if he
harm.
does not file Vokalatnama, then it will be ex parte.
My lord,
Not even
kindly observes that, my lord. Then kindly, my lord, observes in the order. My lord, next date, I'm sure, my lord, the same submission will be made. And with the burden of my lord in this court, my lord,
confident that you will be able to obtain Vokalatnama?
Confident, my lord. I am confident my application for
let them take an undertaking
is
there.
also.
Well, let the undertaking be noted.
Now, if my
that is
on the basis of submission of Mr. Gupta,
yes,
the matter is kept on 3/11/2025 under the same heading.
With an undertaking, my lord, kindly let them undertake that. Otherwise,
if your statement is sufficient, lawyer's statement is sufficient in court.
My lord, then the liberty be there to take necessary steps to be by the plaintiff, my lord. That was there in the last order, my lord. I'm humbly submitting
Yes, plaintiff is also granted liberty to take necessary steps in the
matter.
meantime.
My lord, one more, my lord, thing is that there was another suit between the same parties. Mr. Gupta is appearing for defendant number 1 and 2 in that suit as well. That also appeared in 3rd September.
Okay, mention it on the next day.
It was directed to appear today, my lord, but it is not.
Okay, give the slip, it will appear.
It was returnable today only.
Let this appear on the 3rd itself.
My lord, Mr. Gupta was supposed to take steps in that matter as well.
No,
let it appear on 3.
Statement is already on recording.
Have you served it on?
Yes.
On 3 বারোতে ওটা দিয়ে দেবে।
The amended copy.
না না এটা তো ঠিক আছে। No, this matter will appear on 3/11. 3/11.
Very good.
আর ওটাও 3/11 এ
Yes, my lord. Thank you.
I'll take instruction.
My lord. An old GA of
2005.
Yes, 1467. My lord, this was disposed a long time back, my lord. This is the last, this is the order. Yes, my lord. Let it be treated as different, disposed of, and let it be marked as disposed of.
As GA 1467 of 2025, 2005 is already disposed. Let it go out of the list.
I'm grateful, my lord.
Complete হয়ে গেছে?
সাত তারিখে ফিক্স করা আছে এন্ট্রি অর্ডারটা এক্সটেন্ড করতে বলছে 1 তারিখে লোয়ার কোর্টে ঠিক আছে হ্যাঁ না না আমি করে আমাদের 7 তারিখ হ্যাঁ হ্যাঁ 7 তারিখে ফিক্স করা আছে অর্ডারটা তুমি 21 তারিখ অব্দি করে 1 ডিসেম্বরে
Item number 1. My lord, this matter requires detailed hearing, my lord. My lord, the interim order is till 7th, my lord. Kindly hears the matter on 7th and extends the interim order till 21st of November because the date fixed in the court below is on 1st December, my lord. If my lord takes it up on 7th, my lord, perhaps it will take 1 or 2 days, my lord.
This is an assigned matter?
Yes, my lord, assigned.
Yes, record an order. You are for the opposite party. Learned advocates for the parties are present. Let this matter appear on
Friday week, my lord.
7/11/2025 for hearing. The interim order granted earlier stands extended
Till 2nd week of
No,
December.
no, when it is going to expire?
My lord, it is going to expire on 7th, my lord. So 7th.
7th of this month?
Yes, ma'am.
Oh, 7th of November?
November. My lord,
The interim order
extended.
granted earlier stands extended till 6/12/2025 or till further orders, whichever is earlier.
Item number 2 for order.
And for the opposite party
Yes.
to your lordship.
Yes, now the question here is this. Yes, give the records. Hey.
Okay, we had handed over the case diary.
No, here you see one thing. The order could have been passed, but the thing is this. One of the accused person is not made a party, so it can't be partial quashing of the case. So I am granting you liberty to
One has been
include-
discharged, my lord.
No, whatever it is, discharge and quashing ultimately.
No, one has been discharged as a result. Discharge.
No, he still is an accused person.
Sure.
In the charge sheet, this person was
But
slain.
it was allegation was against the mother and the principal accused, that is the
Question is,
petitioner.
the entire case has to be quashed.
Yes,
Okay.
my lord.
Now the question is, there cannot be any partial quashing. So,
My lord, lordship will kindly order charge order.
No, where is you see, in the charge sheet, this person's name is there.
Yes, my lord, I'm coming to it. 25/25 মনে আমি বলতো 25/25 My lord, lordship kindly comes to order dated 25th of April 2025 of my brief, my lord, of my petition.
25th of April?
Yes, my lord, 2025.
So which page?
But that is the certified copy, as a result of which, my lord, we are not allowed to be allowed to pay it, my lord.
Certified copy?
May I get it for you?
Certified copy of which order?
25th of April 2025 of the petition, my lord. Last
In the petition, you have stated that.
Yes, my lord. Kindly comes, my lord. It's there. Last 3 পাতা, 3 নম্বর পাতা.
Okay.
Yes,
certified
my lord.
copy.
Kindly see the second last paragraph.
25th of April, it is.
Yes, my lord.
Okay, 25/4/2025.
Yes, my lord. My lord, second last paragraph ordered that the accused such and such is discharged from the case. She is also discharged from the bail bond and is set at liberty. This is the order of my lord, framing of the charges. So
Okay.
charges.
So this person, this accused, that is the mother of the petitioner,
Yes,
is
my lord.
already discharged.
Yes, my lord. That is why, my lord, we have not made her a party. Or else, my lord, we should have, would have done it.
Okay, so let it appear for orders tomorrow
As
or
we-
day after tomorrow.
I'll get with you, Lordship.
Yes, record an order. Learned advocates for the parties are present. Let this matter appear for orders on 29 না না এ তো বুধবারই রেখে দিচ্ছি 29/10/2025 okay 29/10/2025
Yes.
এবারে বাকি হ্যাঁ বড় অর্ডার্স ওই 29 তারিখে ওই 29 তারিখে ওই দুটোর সময় যা দু একটা থাকবে দিয়ে দেওয়া যাবে Yes, call the Port Blair matters. It's virtual. Yes, what do you say with regard to the complaints?
My
Yep.
lord, I appear on behalf of the respondent contemnors, my lord, and we have complied the order, my lord.
I'm asking learned advocate.
My lord, I am for the petitioner, my lord. Here,
Yes.
my lord, there is a direction to dispose of my application as per according with law and accordance with law. But my lord, here the case was for the subdivision. Joint consented proposal was given, everything done. After filing of the contempt application, just to escape from the contempt, this order has been passed, wherein on the baseless grounds which have complied with. On the same ground, they have rejected my application. Because subdivision, it will benefit the authority as well as the proposal who has given the subdivision for application given by this co-tenants. Here, my lord, in spite of that, the authority has rejected my application because I have filed my contempt application. Because within time they have not done so, I have filed contempt. After filing of the contempt, they have on this next day itself they have passed this order. The ground, if they have, if your lordship will see, these grounds have already filed the reply by saying that this cannot be done. On this ground, this cannot be rejected. I have given the reply also.
Yes, record an order.
Just to frustrate from the contempt application, escape from the contempt application, this compliance has been given. This order has been passed.
And learned advocate for the opposite party contender are present. Heard learned advocates peruse the affidavit of compliance filed by the alleged contender. It is submitted by learned advocate for the petitioner that the alleged contender arbitrarily rejected her prayer, which is not in accordance with law, just to avoid the contempt proceedings. Stop. Upon considering the order passed and the affidavit of compliance, this court is of the view that nothing remains to be adjudicated in this application for contempt in view of the order passed by the contemners. Stop. The petitioner, if aggrieved by the order passed by the alleged contender, is granted liberty to take necessary steps in accordance with law by filing a fresh writ application. This application stands disposed.
Obliged.
Grateful.
Obliged, my lord.
Yes, all the original site matters.
Yeah, clear করে। সই করে তারপরে না করতে হবে, স্যার করতে হবে।
Yes, you are for?
I'm for the defendant.
Yes.
I'm for the defendant. The matter has been remanded to this honorable court, and from the stage of argument, this matter is to be heard. So this is a suit for defamation, and in this defamation suit, the order, judgment, and order.
Arguments on the part of the defendant has commenced.
No, actually everything was decided. Then the matter went before the appellate court.
Now, this court has to hear out this matter from the argument stage.
The argument stage
Yes.
itself, without
First day it is coming.
without any evidence.
No, question is, you see, the suit was already decided. disposed.
Correct.
Thereafter, an appeal was preferred.
Yes, Your Honor.
The Honorable Appellate Court remanded the matter back to the trial court.
Yes, against which SLP was filed.
Yes.
And in the SLP, again, it was decided that let the matter be heard from the stage of argument
Yes.
without affording any opportunity to lead evidence to both the parties.
So, this court is to proceed from the stage of the
Yes, my
argument.
lord. Yes, my lord.
So,
Only from the argument.
So, you submit. You are
Yes,
for
my
the
lord.
defendant.
Yes, my lord.
Yes, give the records. Yes.
This is a suit for defamation.
Yes.
Wherein the cause of action has arisen due to purportedly defamatory email dated 9th of July 2008. The relationship between the parties is very old, and therefore, my lord, I would like to throw some light on the checkered history of this entire transaction, because the defense has been taken by the defendant in entire proceeding is that the word which is allegedly defamatory is not defamatory, but the defense of truth has been taken. So therefore, in order to know the circumstances, it is necessary to see the checkered history. So therefore, I will first of all reflect on the previous incidences of transactions between the parties. Before that, I would like to point out to this honorable court that the order which was passed by this court previously in the year 2015, wherein damages of 50,000 euros was awarded and a cost of rupees 1 lakh was saddled. Now, this particular word euros, how it has come, so I will explain the history in my history part of it, Your Honor. Firstly, the about parties. There are three parties here: plaintiff 1, plaintiff 2, and the defendant. Plaintiff is the manufacturer of a product which is called as coupling. Plaintiff number 2 is an exporter, and plaintiff number 1 and 2 belong to the same group of companies. The defendant, Vulcan Technologies Limited, is a company formed in the year 2000. The company is a subsidiary of a German company, namely Vulcan Couplings GmbH Germany. Hereinafter, I will refer to it as Vulcan Germany.
It's a private limited company.
Yes, it's a limited company, a family-run company in Germany. This is 125 years old company, a family-run company, and having almost monopoly as far as this particular product is concerned in the entire world. And this German Vulcan company has got various subsidiaries which are independent all over the world. And one of such company is in India, which is called as Vulcan India, henceforth, Your Honor. Now, this Vulcan India established in the year 2000. Prior to that, in the year 1980s, the plaintiff group, that is ESBI, I will call henceforth as ESBI, that group. ESBI and Vulcan Germany had business relations since 80s. These are all admitted facts, my lord. In the year 1995 or around so, the dispute started between ESBI and Vulcan Germany. The disputes resulted into various disputes in Kolkata High Court, in Singapore Court, and elsewhere. Ultimately, both the parties admittedly reduced into writing a global settlement agreement in the year 1997, my lord. Now, in this particular global settlement agreement, both the parties peaceably decided that let's part with the business. You will not deal with our business, or you will not use our name. Not only that, you will not use our model codes also, names also. Now, this is part of record, my lord. Having said so, in the year 2000, Vulcan Germany started its own company, that is present defendant company. Now, it so happened that Vulcan India, that is the defendant, and plaintiff ESBI, they become competitors of each other. Earlier, ESBI was doing business along with Vulcan Germany, so it took, or it got the benefit of its monopoly. Now, since Vulcan Germany introduced its own separate company in India, they become admittedly competitors, and that is why exactly it is stated in the plaint in paragraph number 9. It is stated that they are business rivals.
Yes.
Paragraph 16 read with paragraph 9.
Para 9.
Para 9. I read.
Yes.
Para 9. Apart from supplying couplings to various manufacturers who use the same as part of the original equipment manufactured by them, the plaintiffs also cater to the market for replacement of spares of other manufacturers, including inter alia the defendant, its parent company, namely Vulcan Couplings GmbH Germany and Hackforth GmbH Germany, and or its foreign associates. Because of the quality of the plaintiff's products, international customers often demand plaintiff's products as replacement for the parts of the other manufacturers, including the products manufactured by the defendant. Now, my lords, I will read paragraph number 16. Since then, the plaintiffs and the defendant are business rivals competing in the global and domestic Indian market for the spares and original equipments. My lord, it is necessary to highlight the strained relationship or the sense of rivalry which is admittedly there between both the parties. Because
earlier there was terms of settlement. Earlier there was dispute that was settled. Commercial dispute was there.
That was with the parent company, that is Vulcan Germany.
Okay.
Vulcan Germany had business with plaintiff from 1980s to around 1995 or so. Around 15 years they did business. Till then there was no problem. The problem arose not with the defendant company, but the problem in the year 1995 arose with Vulcan Germany. That time defendant was not even incorporated. So now in the year 2000, this defendant company has been incorporated, started doing business independently, which Vulcan Germany was earlier doing with the plaintiff. Hence, this is important that there is a admitted business rivalry between the two parties. Now, my lord, something about the product, because product also plays important role in view of this particular pleading. The product is coupling. In this particular case, the product is coupling. Now, this coupling is a mechanical device which connects two shafts to transmit power and motion. Now, this particular device can be used in various industrial applications, more particularly in marine application, in the ships, to give the impetus to the ship, the engine works, and this coupling that plays a very crucial role. So this particular product is a unique product. This particular product is having wide use in various industries and more particularly in shipping industry. Now, this particular product is so specific that it has got its own brand name, or it is known by the brand name of the manufacturer. And as I said earlier, my lords, that this particular German company is 125 years old, and world today also it is the world leader, and therefore the product is purchased in the name of that particular company. Having said so, I come back to the paragraph number 9, which I read just now. There is a word called replacement. Apart from supplying couplings to various manufacturers who use the same as part of the original equipment manufactured by them, the plaintiffs also cater to the market for replacement of spares of other manufacturers. Now I take a pause, my lord, here. What do? They are catering to the market for replacement of the spares. I will give one analogy, my lord, for the understanding of this business model. Suppose I am a manufacturer of Mercedes company, and Mercedes company also manufactures the spare parts of Mercedes company. Now, there may be some other companies in India who may be manufacturing the same spare parts which can be applicable to the Mercedes car. But there will always be difference between the spare part manufactured by Mercedes company itself and any local manufacturer. And my lords, this is the exact point of difference. It so happened in this particular case that purportedly there was a customer of plaintiff. I am saying purportedly because I'm not accepting that it has been proved. So purportedly there is a customer who demanded that you please supply this particular product whose model code is EZ201S. Henceforth, I will use this word EZ201S. Now, EZ201S is admittedly the brand name of that particular product which belongs to Vulcan only. Admittedly, I will show there is a exhibit 2 in cross-examination. The web page of the plaintiff company itself was exhibited. I will come to it. But point in short, my lord, is that the EZ201S is the product code, and nobody is supposed to use that particular product code as per the global settlement agreement. Now, exactly it so happened that they, according to the plaintiff, their customer wanted a certificate that this particular product manufactured by plaintiff is equivalent to my product. Now, my lord may appreciate that there is a fourth party. So far, I talked only about the plaintiff and the defendant and the German company, Vulcani German. But now fourth party is very important, my lord, here, who is not implemented. That is called as DNV. Its name is Det Norske Veritas. Now, DNV is an internationally acclaimed certifying agency. My lord may kindly appreciate an example of ISI. Like in India, suppose if any particular product, suppose if I have to purchase any electrical product, and if I see ISI mark on that, then immediately I make up my mind without having a second thought and I straightway purchase it. How does it happen? It happens because there is a certifying agency like ISI who, after testing, endorses that yes, your product is safe or good for sale, and therefore the certification is given. So this is the importance of certification. My lords may also kindly appreciate that considering the use of these couplings, now these couplings is used in ships where the customers are spread all over the world, my lord. And therefore, how do you believe that this particular product is having that particular technical specification or standard or not? So therefore, without such certification like ISI, therefore I used analogy of ISI, unless there is a certification by DNV as far as this particular product is concerned, nobody purchases it in the market. And that is the reason, according to plaintiff itself, that their customer demanded that you please supply this particular product to us, but while giving certification or while obtaining certification from DNV, you please obtain it as my product, ESBI product, is equivalent to EZ201S. In short, suppose I'm coming back to the example of Mercedes car. Now, suppose a local manufacturer gets a certification from an international company that the wipers which you are manufacturing as a spare part,
No,
they
that means the competent authority to issue the certificate is a neutral body. That's
neutral body. It's a neutral body. It's an autonomous body. It's not a government body.
yes. So
It's
that's
not a government
neutral
body.
That is the competent authority.
Yes,
the certificates.
well accepted by both the parties all over the world also.
Yes.
Like ISO, my lord, ISO 2000, 9000, whatever we have. So it's like that. Unless you have that, nobody in the value, the market, it will not get market value.
Yes.
So I was on the point that suppose if some local manufacturer gets such certification that my wiper is equivalent to the Mercedes original wiper, then obviously the equation changes. Now, at this particular juncture, my lord, the global settlement agreement comes in play. Admittedly, it is stated in global settlement agreement that I will read, my lords may kindly see exhibit 2. Exhibit 2.
Yes, exhibit.
Page number. I have here. পেপার বুকটা আছে অ্যাপিলের পেপার বুক তাহলে জজ সাহেবের সুবিধা হবে 188 দাদা জাস্ট এ মিনিট আছে জজ সাহেব এটা বের করতে সুবিধা ওকে আমার কপিটা তো ডকুমেন্ট আমার কাছে আছে এখানে এখানে এটা মনে হয় অ্যাপিল কোর্টে ছিল তো আসলে সেই জন্য আসে আছে বাস ওইটা দিন না রাজকীয় ডকুমেন্টস আছে হ্যাঁ ওটাতে হতো 218 this I want 21 is the this is then I want question number 246 আমাদের আমার কাছে একবার বের করে Registry of document. Yes. Huh? Document. Sorry, it is the paper book. Your High Court paper book you gave me. It is paper book. It is not. देखिए इटा तो we have to see बेर code exhibit 2 which we referred in cross examination. Huh? No. Exhibit से अलग करे नहीं এক্সিবিটের কপিগুলো নেই হবে হবে এক্সিবিটের কপিগুলো এটা আছে এক্সিবিট 2 এরকম হ্যাঁ it was referred in cross examination yes ওখানেই হবে list of exhibits cross examination it was exhibited he was saying this no this নিচে আছে এটা কি আছে মান আছে হ্যাঁ এটা মান আছে কি হবে এই মান আছে না মানে হ্যাঁ এটা My lord, can I hand over the judge's book of documents, my lord, which used in the appeal court, my lord, the paper book? That is for the custard the matter, and thereafter they will. Yes, yes, that is. No, it looks like this. It looks like this.
No, this has been marked as exhibit, sir.
Exhibit 2.
Yes, yes, this is exhibit 2. This is exhibit 2.
During cross examination?
No, whatever it is, exhibit 2.
Because this was exhibited during cross examination.
If you are referring to exhibit 2, this is exhibit 2.
Just a minute. It's the exhibit 2. Wrong thing has been exhibited to. No, I will show. No, I will show. See here. The taint is still there. Plain. No, not in the plain. In the question number 246.
246.
Question number 246. $247 to be precise. 46 and 247.
Yes.
This one.
The web page is tendered and marked as exhibit 2. Yes, so this is the web page.
Which one?
Is this a web page?
No.
Yeah, yes. This is a web page.
Then there is one more. Actually, it should look like this. See, this is the web page.
No, then what has been tendered is that. So maybe this is something else. This is exhibit 2. This has not been tendered.
Annexure B, it is written.
Yes,
Annexure B.
annexure will be different.
Annexure B, can you please check?
I'll check it, annexure B. Annexure here. Is
No,
this?
not this. This was in the High Court.
Maybe, is this an annexure from some other proceedings along with the other papers?
See, this is how it was filed. This is Sorry?
No, no, exhibit 2 এটা নেই।
Unless my apology, there is some discrepancy, but it is a genuine discrepancy. I will look into it. But meantime, may I proceed?
Yes, yes,
Come
yes.
back with this document later on. Actually, the difficulty arose, my lord, because according to the paper book which you have, which was referred in the
appeal court.
appellate court also, correct? So in this particular case, question number 246, which was asked in the deposition. So I will start with that. So question was put to the plaintiff's witness. I am showing you the original printout of website of ESBI from which the copy at page 42 of judge's brief of documents has been prepared. Kindly tell my lord whether this is a printout of the original web page of the plaintiff. Then answer is the web page is subject to modification and this is a modified copy of the web page. Next question, who according to you has modified the web page from which this printout has been obtained? Then he says, I think this is the same copy. And then the web page is tendered and marked at exhibit 2. So this is what I have, my lords. And the copy is also there with me. It is a web page copy. And the copy which I am seeing as of now is not web page, the first page which I want to prove. So that is, I am not seeing it. With the permission of my lord, may I kindly
proceed?
And subject to my production, my submission may kindly be considered.
Yes, yes.
May I submit the copy till then for the
Anyway, after all, you submit your written notes of arguments also.
Yes, my lord.
So there you can
only one thing, my lord.
you have to
subject
submit
my
the compilation also.
Yes, my lord.
Written arguments as well as the compilations.
Yes, my lord.
My lord, exhibits are there, whatever has gone in, my lord. Because now if my learned friend, my lord, exhibit is clearly marked there as exhibit 2, my lord. If there is something else which is an exhibit, my lord, that stage is gone, my lord, because your lordship will also consider the order of the Honorable Supreme Court.
Whatever is there in the record, the court will
that is
consider.
it, my lord. Because otherwise,
Because you see, after submission, you have to submit this argument and compilation and judgments, everything.
Yes, my lord. And I'm not going to make any introduce any new document, but this is I'm referring to the appellate court paper book only. And there may be, because the documents are in volumes, your honor, so therefore there is a possibility. So subject to that, I may be allowed.
Anyway,
and meantime, may I request my lord to see the document which I am referring? I can give a copy. Page number? No, this 144.
lordship will decide, my lord, later, my lord,
Yes,
once my learned friend
Yes.
goes through it, whether now these documents what my learned friend is relying upon can be looked into, whether these have been marked as exhibit or not.
No, if it is marked exhibit, then only the court can go into
Absolutely,
that.
my
Otherwise,
lord.
the court is powerless.
Absolutely. Because these have not been marked as exhibit.
So no question.
Yes, my lord.
Because in the deposition, it is stated that it is exhibit 2. Now, exhibit 2 is something else, my lord.
That
because
is not web page. That
well,
is also
whatever
fact.
it is, but what has been marked has been marked.
Anyway, which page you are relying? Page 146.
144, my lord.
144, yes.
It is written as annexure B.
Yes.
Now, now this is a web page. Now in web page, what the plaintiff company has stated, let us read, my lord. Introduction. Please note that ESBI is no longer known as ESBI Vulcan. ESBI no more manufacture Vulcan branded couplings or Vulcan spares. According to the global settlement agreement between Vulcan couplings and GBHM, Germany and ESBI and others, we have no more produce Vulcan EZ spares or Vulcan EZR spare neither we use the code number of series EZ, EZS and EZR. We do not have alternative code.
No, we do have.
I'm sorry, my apology. We do have alternative code numbers of our products which carry the brand ESBI only. So now they are after the global settlement agreement, they are supposed to not manufacture, they will not use EZ, EZS, EZR, and not only that, they say that which carry brand ESBI only. So they are in the clear words, it is admitted neither we use the code EZ. Now, the crux of the issue is here, my lord, that they wrote a letter to DNV that we are giving this specimen sample of the product. After examination, if it is worthy of sale, please grant a certificate stating that ESBI product is having equivalence with EZ201S. And this is the problem, my lord. When DNV did not know that this is Vulcan product, they tested it and they gave reference as it is that this product equivalent to EZ201S. When this particular fact came to the knowledge of defendant, what defendant did? Defendant wrote the impugned email to DNV. Now, with this background, I request my lord to read the impugned email.
No, the impugned email was in reply to any query from the authorities or on your own.
On my own. When I came to know,
you came to know from which document you came to know?
No, in the market we came to know that such and such equivalent
That is,
certificate.
you see, with regard to one query is one thing, and on your own that is another thing. Anyway,
Yes,
whatever
ma'am.
it is,
Yes.
it is there. That is page 146.
Yes, 146.
Yes. This is
That is
addressed
D2.
to
D2
no page 146 of this book.
but yeah, but D2.
No, whatever it is C.
C, yes, C 146.
Yes.
And in original suit, it is exhibited as D2.
Whatever it is, you clarify.
Yes, ma'am. And I read from Rajesh Mishra at vulcanindia.com to Kamal Kumar at dnv.com. Date 9th July 2008. Subject, it is forwarded WG Vulcan EZ201S installing ESBI elements with DNV test ? I read, dear Mr. Kamal Kumar, kindly refer attached certificate issued by DNV Kolkata. In this certificate, Vulcan brand name EZ201S is mentioned as equivalent to a coupling manufactured by ESBI Transmission Private Limited, Kolkata, India. We have a strong objection that a reputed certifying agency like DNV certifying some other spurious manufacturer product equivalent to a product manufactured by Vulcan Couplings and Getribu, that is GmbH. We have no objection for manufacturing the rubber element by ESBI Calcutta, but they should use only their model number. They should not use the model number of Vulcan, full stop. It gives a very wrong picture to final customer. You are requested to immediately withdraw this certificate. For your information, Singapore court has already passed the order and banned ESBI from using Vulcan brand names and their part numbers. Hope you will do the needful at the earliest. Regards, Mr.
In
Rajesh.
receipt of your letter,
Yes.
did they issue any
Yes.
notice upon this?
Yes, yes,
Yes.
yes. And after giving an opportunity of being heard, in due course of time, when DNV realized that this is a case of misrepresentation.
Wait, so this plaintiff appeared before these authorities, DNV authorities?
Yes, my lord. And thereafter, the certificate was withdrawn.
No, that was withdrawn definitely
Yes.
on your representation.
Yes, ma'am.
But they served notice and
Yes.
they heard them.
Yes, yes, my lord. Now what has happened? Once the
That means, in accordance with the procedure,
yes,
they
yes,
have withdrawn the
yes,
certificate.
yes, yes, with due
Whether
knowledge.
that is your case or not.
That is my case, and my case was that I am making a complaint to an authority.
Whatever it is, I am asking you whether
Yes, my
the
lord.
authority unilaterally has done it or upon giving
After
them an
giving
opportunity.
after giving opportunity, my lords. Now it is the case. Now I come to the statement of claim. So once this particular authority or certificate was withdrawn, it is the case of plaintiff that it has resulted into harm to a reputation, number one, and therefore they claimed damages of rupees 50 crore.
Now, this is this authority, is it a government
No,
authority?
no, my lord. As I said, it's an autonomous
Now the
authority.
question is, there is no scope of any appeal against this authority. That
No.
means it has to be challenged
Correct.
in a suit.
Correct.
There is no
Correct.
appellate authority.
Correct. But they accepted it. They did
Whatever
not.
it is, it has to be challenged in a suit.
Yes, my lord. And they did not make DNV as a party to it also. And that was my one of the defenses, that DNV was a necessary party, but still it is not been made. Yes. So, my lords, now the claim is of rupees 50 crores for the harm to the reputation and alleged pecuniary loss and loss of profit, 8 million Singapore dollars each, that is 16 million Singapore dollars. Now this I come to the statement of claim, my lords. And now this entire claim is arising out of only one word, that is spurious manufacturer. And in this case, the defendant did not lead evidence based on the evidence which was there on the basis of cross-examination of the plaintiff's witnesses. My lord, I'm told that there is a fixed matter at 3 p.m. So
yes, so the
so
court
I will
will have to rise at 3:15 also. So anyway, I shall take it up on some other day.
My lord, your honor.
Yes, record an order. Learned advocates for the parties are present. Heard learned advocates. Hard arguments made by learned advocate for the defendant. Let this matter appear for
My
further
lord, is it
hearing.
possible to keep it on Monday? I come from Pune. If it is convenient, otherwise as per convenience of my lord.
আচ্ছা 10 তারিখে দেখুন তো কোনো ইয়ে আছে কিনা
Will do.
3 বা 10 যে কোনো একদিন
Fresh for him also.
হ্যাঁ 3 তারিখে next Monday
What is the date?
17
I'm sorry, 3rd is not. 10th is possible. Or any other. 10th is Friday. 10th has to be Sunday only, Monday only.
11 তারিখে দেখুন 11 10 অনেক আছে আচ্ছা 12 তারিখেও তাই, আর 17 তারিখে
10th is okay. 10th, let us see. Otherwise,
okay 17/12/2025 at
Grateful,
2 p.m.
grateful, my lord. Grateful, my lord.
17/12.
17/11/2025 17/11/2025 at 2 p.m.
Grateful, my lord.
The next matter is item number 3. That is, that was fixed in 3:45 today.
Yes, so
Witness is there, Miller. Let us start.
3
I will just.
3:45. No, there is another matter fixed at 3 p.m. also. So you see, the court has to rise at 3:15.
Yes, I am only indicating. May that 3:45 matter be kept on a next date. Yes. The next. I'm not.
So yes, 3:45. Your matter.
3 p.m. The witness is waiting.
Yes, 3 p.m. No, 3:45. You are appearing.
Yes, I am appearing.
ইয়েতে দেখুন তো এই বুধবারে কিছু, বুধবার কি শুক্রবারে কিছু, শুক্রবার হবে না বুধবারে? হ্যাঁ বুধবার, এই পরশু বুধবার।
আমাদের ডেট রেখো, মানে আমাদের একটা স্লট রেখো ভাই, আমাদের একটা স্লট লাগবে
এই বুধবারে। এবার শুধু ছুটি 3 তারিখ, হ্যাঁ ফ্রাইডে, ফ্রাইডে তো সেকেন্ড হাফে তো আর হয় না। আচ্ছা ঠিক আছে, ফ্রাইডে তো আবার অ্যাপেলেট সাইড রাখতে হয় আর কি। এনিওয়ে, আর ইউ এগ্রিয়েবল টু হ্যাভ ইট অন ফ্রাইডে at 2 p.m? আচ্ছা, item 3, let this matter appear. Learned advocates for the parties are present, no time today. Let this matter appear on 31/10/2025 at 2 p.m. ফার্স্ট হাফে সাধারণত এগুলো হয় না, ফার্স্ট হাফে সাক্ষী টাকি সবই 2টো কি 3টে এগুলোতে হয়, ফার্স্ট হাফে সাক্ষী হয় না। হ্যাঁ 2 p.m. থাক, তারপর দেখা যাবে।
Item number 4 fixed at 3 p.m.
May I appear for the petitioner, the propounder, my lord?
Yes, today is fixed for cross-examination.
My lord, I was in the midst of the cross-examination, my lord.
Before my learned commences.
এগুলো দেখে নিয়েছিস তো কারেকশনস গুলো? হ্যাঁ ওইটা, হ্যাঁ ওটা তো অনলাইন দেখতে বললাম। What she said. Yeah, personally check. Otherwise, others are all typo. ওটা আমিও দেখেছি, that line. She
Show
said.
me Ganati.
Then you have to check it. ওই তোমার এই লাইনটা, সেটা ও বলেছিল, আমি জানি দেখিনি। But she said I relied on her. There's no occasion to disbelieve her, na?
Yes, so please proceed.
My lord, one of the other corrections which are indicated.
Yes, passed an order probably on the earlier occasion.
No, your lordship, this not for these two days.
My lord, the others orders has been passed till that date. So there has been 2 dates thereafter. Some corrections are there, but I find these corrections are only grammatical corrections
Anyway,
of
just
noun
proceed,
pronoun.
thereafter I
Yes,
shall see.
yes, I'll proceed.
Yes.
Mrs. Banerjee, you had deposed to have done your graduation from Osmania University, comma, in which state is this university?
Andhra Pradesh, then Andhra Pradesh, now Telangana.
What was the reason for you for doing your graduation from the then Andhra Pradesh, from the then state of Andhra Pradesh?
I had shifted to Hyderabad when I was in class 9.
and thereafter I continued my studies in Hyderabad, and therefore I graduated from Osmania University.
Till which year you stayed at Hyderabad?
I stayed in Hyderabad till the year of 1999.
So I take it that you joined Standard Chartered Bank first in Hyderabad only.
Yes, I joined the then ANZ Greenlays Bank, later known as Standard Chartered Bank, in the year 1992.
কলকাতায় কবে শিফট করেছো? 99 না?
Yes, 1990.
After shifting to Calcutta in the year 1999, what was your residential address?
After shifting to Calcutta in the year 1999, I first stayed at the official accommodation. Thereafter, I moved to a paying guest accommodation in Wood Street.
Wood Street.
My place of work was 41 Chorangi then.
And what about your parents? Where they resided?
My father passed away long back. He passed away in 1993. And my mother resided with my eldest sister in Hyderabad.
What was your age when you joined Standard Chartered Bank in Hyderabad? ANZ Greenlays Bank in Hyderabad?
That's I'll have to do a little bit of a calculation. I was 24.
Mrs. Banerjee, you will recall that you had deposed to have received instructions from the testator, Dr. Proshun Kumar Banerjee, for opening bank accounts in your branch at Salt Lake. What was the mode of these instructions from the testator?
It was oral. It was oral.
Will I be correct in saying that he used to call you up on telephone to give these instructions?
No, this was given personally when I visited him. That is, these were given personally when I visited him at his residence in Roland Road.
These personal instructions were during which period?
Between end May, post my registration, and before I moved into my matrimonial home in Roland Road, which was in late July 2008.
What were the specific instructions that you got from the testator regarding opening of other than the opening of the bank account? No, I took it. Sorry, I'm rephrasing this.
Just clarified in a specific
Yes, exactly. It's beginning too vague. Sorry. You had deposed to have handled the banking and financial tasks of the testator.
That's right.
Can you please elaborate these tasks?
I can give a few examples. One was opening of the specific accounts. Second was to check the authenticity of the pay orders that the testator received as consideration for the sale of the Sheikhpura land. Apart from this, whenever he had any mails coming from Patna, I meant postal mails, he relied on me to respond to the same.
And these instructions were given by the testator himself to you.
Yes, they were given by the testator himself. Given by the testator himself.
So, other than the task that you referred to in your last answer,
That's right.
I believe that there was no other activities that were assigned to you by the testator?
Specifically, I could recall only these three, but there were others as well. Sometimes he would ask me to draft responses to the letters which came from his banks in Patna.
And for drafting these responses to the reply letters, the instructions you must have been receiving from the testator himself?
He would ask me to draft the letters, the responses, post which I would have to read out to him line by line, read out to him line by line, and only after he endorsed was the final letter made out.
How did you know what to draft? These instructions you must have received from the testator?
Yes, he would slowly give dictation, and then the rest of it, he would wait until I finished, mainly the salutation and the ending of the letters. And thereafter, it would be given to him. It would be given back to him for the final response.
Yes, one more question and thereafter.
Well, I'll finish. I won't answer. Next day. Next. I just, don't you will have to go?
Yes. Record and order.
I have to go.
Learned advocates for the parties are present. DW1 is present in court. DW1 is cross-examined in part and discharged for the day. Further cross-examination is deferred as because there is no time today.
The depositions for 5th August and 20th August has corrected or handed over. Corrections will be incorporated.
Yes.
The deposit corrections in the.
Wait, just a minute. Let this matter appear on.
But any day other than this coming Monday, whatever.
13 তারিখে দেখুন তো কি আছে
13ই ও বাবা
13 বা 6 তারিখে আর 6 তারিখে
লসি মেক ইট 6th হবে না
6 তারিখে কি
6th হবে না মানে 7 8
13
বাট 13
এ কি দুটোর সময় কোনো আছে 3টে থেকে আছে ওকে 13
মানে 13th is a problem can we make it on 12th 12th থেকে করব হ্যাঁ এইচপি বাগড়ি আছে হবে না আমি জানি এই এইচপি পাগড়ি একটা আছে হবে
12 এ 2 PM আছে 3 PM ওর কি উইটনেস অ্যাকশন আছে নাকি অন্য কিছু 12
3:30 or আবার 3:45 is a difficult or 11th পেছোতে চাইছি না মানে সাক্ষী আছে তো ডকে সেই সুবিধা 11th
আচ্ছা let me
subject to sorry
let it be on 12th. Okay, let something be proceeded.
Yes,
Otherwise
okay.
it will be
12,
difficult to
12,
complete
12,
12 এ কি দুটোর সময় তিনটেও আছে দুটোতেও আছে তিনটে থেকে কি দুখানা আছে ওকে at 2 PM
2 PM
তাহলে
এটা হবে
12th at 2 PM
12th at 2 PM আমার এটা এখানেই আছে হবে এটা এখানেই আছে
12/11/2025
দেখবে এইচপি
at
পাগড়ি
2
আছে
PM
ওটা হবে না
আচ্ছা
এখানে
let the learned advocate submit that necessary corrections be made in order or deposition
Deposition dated 5th August and 20th.
in the deposition dated 5th August 2025 and
20th August.
20th 20 August 2025. Let the rectifications as submitted in draft by the learned advocates be given effect to.
obligement